figure out why.
They think it's not a life or death on that. We hope so. Anyhow, hopefully a couple more days and they can get home. Yeah, it's been a long 2 weeks for them. Yeah, thanks.
Thank you. Well, it's time for us to begin a meeting. We'll call to order. I guess today is September 2nd, 2025. It's 9:01. We'll have a roll call.
Commissioner Mon here.
Commissioner Stubbs here. I think Commissioner Harvey is on the way. We'll have a couple items in the agenda, and I'll turn the time to Mac.
All right. Today, the first item on the agenda is training on land use provided by the Office of Property Rights Ombudsman. We've got the director here, Rob Terry, to give us this training on here. Let me tee it up real fast so that you can see what he's going to be presenting on. Then, Rob, I'll turn it over to you to run. This awesome mouse.
Sounds good.
It's all you. Let me turn down this microphone so it doesn't.
Thank you very much, Mac. Appreciate the opportunity to be here this morning. Thank you, commissioners. Glad to be in this beautiful geography this morning. While I was raised in Utah, spent the last I've been back home for about 3 years, but it's been about 18 years in Central California. I married a California girl and went to California to be closer to her family, take care of items there, and finish school. So a couple items. One, desperately missed Utah while I was gone. So I always drive a little bit slower when I'm going to, all four corners of Utah as I'm bringing back in the geography and enjoying that. So I drove down yesterday. And second, wanted to make sure that you guys knew if I have a slip of the tongue, I wanted to apologize beforehand. So the majority of my time in Central California and planning was spent in the San Joaquin Valley, which is very close to San Juan. So if I accidentally say San Joaquin, my apologies up front. That's going to be where that 18 years of planning simply came back in. So I want to apologize for that up front. If you hear that, please know that that's what that is, and that's not intentional.
Because you love both, like our kids, I was calling them the wrong names. So
oh, yeah, absolutely. I'm the youngest of 7, so I got called every single sibling's name, how that went, yeah.
My husband's mother included a dog.
My dad tried to name me Toby, which is basically a dog's name. So I probably would have been close. Well, again, thank you for the opportunity to be here. My name is Rob Terry. I serve as the statewide land use training director. I'm housed out of the Office of the Property Rights Ombudsman, but I'm the only non-attorney in the office, which we have phenomenal attorneys there. But as you know, attorneys look at very different items as opposed to land use practitioners. So you'll note that while I certainly will talk about land use law and things that are related to land use law today, there will be a lot more concentration on planning best practices and things of that nature, although I do have a lot of experience with land use law as well, so can certainly answer some of those questions. But if things get really specific on items, I may end up actually referring them to the one of the attorneys within the office if there's any specific items there that need discussion. I've had the opportunity to be in planning for just over 20 years at this point now. I've had the chance to serve at the local, regional, and state levels of government. So served everywhere from the deputy city manager at the local to principal regional planner at the regional level, and then as the statewide land use training director right now for the state of Utah. So have a lot of experience and have had the chance to have a lot of discussions going across a very broad spectrum of planning, transportation, local government, state government, you name it. So, but as I said, I'm housed out of the Office of the Property Rights Ombudsman, and we have the opportunity to serve the members of the state in 4 primary ways. I focus on the very first bullet point that you'll see here, which is information and education. And that's to work with both government agencies and private property owners and everything in between to talk about how land use law and the legal process works, what rights people have, what land use laws are in place, things that they need to be aware of as they're navigating the landscape of land use. The attorneys in our office then will focus on negotiation and serve as liaisons in between typically private property owners and government agencies. The things that they do the very most are going to be whenever there's anything that it's going to involve eminent domain or something closely related to that. They're going to work with liaisons to ensure that the local and or state officials, depending on what the project is, understand the process that they need to be going through to ensure the private property owners' rights are understood by them, and then work with the private property owners to make sure that they understand what their rights are and how they should be dealt with and what the process is to ensure that there's good communication there. So they will do that with a lot of mediation, which is, I think, an extremely effective thing and very, very good, as they'll bring all parties to the table and have discussions. And one of the items that they do that has been the most effective, they're going on 400 of these now over the last, I guess it's been about 15, almost 20 years at this point. They do something called an advisory opinion. And an advisory opinion is when either a private property owner or a government agency has an issue and they're saying this could very easily go to litigation. Then they will contact the ombudsman's office and they'll request an advisory opinion. All parties will hand over all of the information about the case, all the background, the facts, and everything. The attorneys will sit down and go through case law, state land use law, and all of those details. And then they will say, if this were to go to a judge, this is likely the way that this judge would rule based upon the facts of the case and what land use law says. And then it can help further mediate the issue. So an advisory opinion is $150 as opposed to tens of thousands, which it's very easy for full litigation to get to. So it works as part of that mediation process, and oftentimes will help both parties get much more comfortable with, okay, this is where we are and this is where we think that it would likely go. And oftentimes the parties will then choose to simply mediate with each other and come to a resolution outside of going through the full litigation process. So very, very effective type of item. Something that we had enhanced here in the last couple of years is the Land Use Academy of Utah, commonly referred to as Luau, because if you learn anything about planners, we love our acronyms, and everything has to have a good acronym, or you've already failed your project, right, is the way that planners are going to look at that. But Luau is an excellent resource. It is seen as the central repository for all things planning related within the state of Utah. So it has everything from templates that can help with local government issues all the way up to state law items and resources, guidebooks, things of that nature. Hundreds of hours of presentations, of videos, and it's constantly growing and evolving. So whenever there's a new training resource or any type of land use resource coming online, it's going to have a home on the Land Use Academy of Utah. So the website there is luau.utah.gov, and that QR code will take you right to that if you guys are interested in looking there. The most recent resource that's been added is the Missing Middle Housing Toolkit for the state of Utah, with some really, really good background information on what missing middle housing is, what it means for individual communities. The most important thing I think out of it is that missing middle housing many, many times is a conversation that is simply just had in more urbanized areas, but there's a lot of focus on what does missing middle housing look like in more rural areas, and what does that mean for your community, and what types can fit there, and what type of resources are available. So it can be a really good thing to take a look at there, and can certainly help as communities continue to address housing throughout the state of Utah. Okay, so some of the planning basics. So first and foremost, everything that is land use law related within the state of Utah is going to have its foundational base in the Land Use Development and Management Act. And of course, commonly referred to as LUDMA, because acronym, right? We have to have an acronym. I won't go through each one of the items here, but I do think that the first three are very important to understand, because they really set that tone of why do you need to have any type of act in place. So first and foremost, it's to provide for the health, the safety, and the welfare of each individual community, but of the state as a whole. It's to promote the prosperity of each individual community and the state as a whole. And then it's to improve the morals, peace, good order, comfort, convenience, and aesthetics of each municipality and each municipality's present and future inhabitants and businesses. I really like in the fact in subsection C there that they point to each municipality and each municipality's present and future inhabitants and businesses. The reason why that matters is because there is a traditional focus in the state of Utah of understanding that it is local communities that make up the entire state. It's not the other way around. I have worked in areas before where it definitely felt a lot more of that top down. And in Utah, it's much more of the bottom up. It's the local communities that have their individual needs, their own individual desires on how they want their communities to look and to operate and to feel. And that autonomy is something that's very, very important. But then you take all of those communities together, and that's what makes the state. That's what makes the state such a great place as well. So you'll notice as I'm going through this presentation that there's areas where the state maintains, and it's very important that this is local control type of items. They'll set the tone on something, but then they'll say, but everything is up to the local agency in order to maintain the look, the feel, the aesthetic, and the operation of their communities. So what are some of the tools that are used to do that? So first and foremost, you have your general plan. The general plan is a mandated document that is intended to guide the growth of your community, growth and any type of development that you're interested in within your community. It sets land use visions and policies out for your community, and it should consider not only today, but primarily it's going to focus on what do we have today and what are we looking to go out into in the future. So typically they're going to have 10 to 20 year horizons, but that can change depending on what the agency is taking a look at and how they feel their community needs to address the items. I have been in communities before that have had general plans that have a 5 to 7 year horizon, very fast growing communities that feel that it's something that they needed to fully revisit very, very quickly. I've worked with some that have had 25 to 30 year horizons before because they may not be growing as quickly, or they may have a little more focus on just certain areas that they have really put a lot of their time and attention into, and felt that there wasn't other areas of the community that needed that same intensity of planning because of how they were currently operating or intended to operate in the future. But it is important to note that general plans are intended to be living documents, which means that they should be able to adapt to the desired needs and the changes of the community as that happens. So even though you may adopt a general plan and say you have a 20-year horizon on that item, that doesn't mean that if an opportunity comes up or a concern arises somewhere that you shouldn't or can't go back into that general plan and make appropriate changes. It is the plan for your community. So if you as the commission are feeling that there needs to be items to change there, if staff is bringing items forward where there's concern or consternation about something, or the members of the public that are bringing forward items or business opportunities, always know that the general plan is something that can absolutely be reopened and reevaluated and adjusted as you feel appropriate for the community. And if you do have any questions or concerns as I'm going through the presentation, please feel free to jump in at any time. So Section 1727A 204 details the process of amending a general plan. So the general plan, of course, is a required document to have. Once it is in place, there is then the process that you have to go through to ensure that as you are opening that plan to make any changes, that there is public notice that is going out to ensure that the public understands that there's going to be a change to this policy document. Amendments should always be considered with a lot of forethought and care, right? So oftentimes the majority of the changes that I've seen happen with general plans are if some type of business opportunity comes forward that was not known at the time that the general plan was initially adopted. And while that's certainly a legitimate reason to open a general plan and to make adjustments there, you always want to make sure that you are mindful of any type of what a singular change can be and what type of impact that could end up having on other areas, right? I remember a cartoon when I was growing up about, I think it was a Wile E. Coyote pulling a lever on something, and it seemed like every time he pulled a lever here, items were going wrong over here, so he was running back and forth. And oftentimes planning things can be like that with those unintended consequences. So it's extremely important to understand as you're making any type of change or adjustment to any plan, but certainly to your general plan, that you want to do everything you can to make sure that you're doing that with forethought and that you're understanding that any change here may have other impacts here or here, and go through the proper process to have those communications and conversations. And then, of course, always follow the process. So ensure that you are looking right at 1727A204 to understand what is the actual process that is put in place. Because regardless of how well your actual process of communication may be and how good your meetings may be run and the high quality content of the conversations that you're having, if you missed some critical and certain legally required steps for public noticing, the amount of time that a notice has to be out, how that notice has to be provided, it can invalidate your process before it really even begins. And so you want to make sure that when you're putting in the time, the effort, the money, everything to update your general plan, that you understand that process and that you are sticking to the rules of that process to ensure that you have a legally defensible process that is in place. And then if you need help as you're going through technical assistance, as you're going through the process, you can always utilize CERTA staff. So the state does have various positions that they support, and some of them fully fund and some of them provide additional support for, that will help with staff that are right in your region. That are parts of your community that can be engaged in the technical aspects of that planning as a support system. So reach out to CERTA staff. I have them listed there. So we have Jerry, of course, who is the director of CERTA, Jade Powell, who's the deputy director, Todd Thorne, who serves as their regional manager, and then Corinne Olson, who serves as the regional economic development manager. But all of them have the ability and the knowledge to help when you are going through any type of general plan update or a zoning update or anything of that nature. Okay. Did we miss one here? I just want to make sure. Okay, no, we did not. So the land use ordinances, now you have your general plan in place, and now you start talking about, great, we have the vision, we have our compass, right? Oftentimes I will refer to a general plan as setting that compass. Now you're talking about getting into the specifics of what do we do to say, this is the direction that we want to head in. Now, how do we get policies in place that are going to help us in detail get to that? So that's where land use ordinances are going to come into play. Land use ordinances are the written law that is duly adopted by the local legislative authority, and these are the ones that actually get into the specifics of regulating land development within your community. So often these land use ordinances are going to include things like your planning, your zoning, your development, your subdivision ordinances, anything that starts to set out those rules and the specifics. So the best practice, of course, is that your ordinances should always implement your general plan. So if you constantly look at the general plan as anytime we're talking about a policy, anytime we're passing an ordinance, is it in line with our general plan? That's going to be the best practice, because that then is going to keep you headed in that same direction that you voted on with your general plan. I think the mouse gave up here. Oh, there we go. Okay, so zoning. Zoning is going to be one of the most common planning items that you're going to see. And this is where you get into the very specific details and the regulations that are going to manage the actual look, feel, and operation of your community. So zoning is going to control items like land use, density, physical dimensions of development. That's typically where you're going to have your separation of uses, setbacks, lot coverage, things that get very, very specific for now each individual lot within your community. The goal of zoning, of course, is to avoid conflicts between certain land uses and the protection of the overall community. The history of zoning comes from the industrial age, when it was not uncommon to have things like steel mills and wood mills and very heavy industrial type of items that were happening sometimes directly adjacent to or even within residential areas. And you can imagine the impact that would have on people's safety, on the health, the noise, everything of that nature. And so zoning in the U.S., the history came from trying to separate out those items that are noxious when compared against each other, and to have separation between those items. Similar, zoning, of course, is done through the ordinance process. So the best practice there is that zoning should implement your general plan. And it should also be in accordance with the other ordinances that you may have in place, right? So first and foremost, that general plan, and then any other ordinance, you want to make sure that you have consistency between the two. One of the quickest ways to get into legal challenge and just issues between private property owners, the community as a whole, and any type of legislative authority is if it is perceived that you have conflict between, say, a general plan and then your zoning, right? Because people are going to say, we have public documents that are not saying the same thing, and they're not going in the same direction. And it can become very easy for someone to challenge any type of process when you have that type of conflict in place there. I will say the state of Utah does not require your general plan and your zoning to be consistent. There is several states in the U.S. that do require that. Utah is not currently one of them, but there has been conversation at the legislature over the last couple of years about becoming a state that does require that. So once you would have your general plan put in place, your zoning would then have to be consistent with that general plan. And any change that you may choose to make to zoning would then require a change to your general plan and vice versa. It's not currently that way, but there has been a lot of conversation, and the best practice already is to ensure that type of consistency. And if you have that type of consistency, then a change in law like that would not end up being an issue for your community. Okay, so what about the roles and the responsibilities? This is oftentimes, I would say, the area where the majority of the general public ends up getting very confused with local government, is when it comes right down to the roles and the responsibilities, and where they have the right and the ability legally to interact with certain boards, commissions, committees, and how that works. So first and foremost, you have your city, your town, or your county council, right? Or commission. There's a lot of different names that they can go by. But the most important thing to understand there is that these are the legislative or the decision-making bodies for your local agency. So they're going to be the ones that actually make the laws that are then generally applicable to that community, to that county, or to that individual city or town. And they do that through weighing broad and competing policy considerations and having discussions about what they feel the community is looking to have, what they want to be able to see, the type of opportunities they have, the businesses they have, balancing all of these items out, and then creating and implementing policy based upon those discussions. Then a planning commission. Planning commissions are absolutely pivotal for land use management within the state of Utah. Every local agency is required to have a planning commission. Again, you may see some different names that they're actually going to go by, but the most common is planning commission, and they serve in an advisory role. And so the commission is going to review and then make recommendations on land use related items to the local legislative body. So then what about a land use authority? So land use authority is a term that oftentimes is utilized almost interchangeably with a city or a town council or a county commission. And sometimes that's right, and sometimes that might not actually be right, because a land use authority is actually a person, a board, commission, agency, or body, including a local legislative body, that is designated by that local legislative body to act upon a land use application. So it could be the local legislative body, but they may have actually assigned that to a person, a board, a commission, the planning commission. Oftentimes you'll see something like conditional use permits, right? That's something the land use authority has authority to take on. Many times a conditional use permit has been assigned to the planning commission by that local legislative body. However, every agency is required to have a land use authority. So if a local legislative body has not designated an alternative person, board, commission, agency, or body, then it reverts back to the local legislative body. So your community will always have a land use authority. Sometimes that's going to be you as the commission, unless you have assigned that to another person, body, board, commission, or agency to address those items, and you've given them that land use authority for those specific type of actions or items.
Can I ask a question?
Yep.
Okay, like we have Planning and Zoning Commission, there's 7 members. And like, I always attend those meetings as a citizen just to learn the process. But my question is, because we are developing a land use, um, we've been working the last few months about that, and so I try to figure out what our role as a commission is, because I feel like right now we just wait for them to send us stuff, even though they sometimes I feel like saying, okay, we're spinning the wheel here, it's not working, can we look at a different direction? So I don't know if we wait and let them just keep spinning the wheel, or do we have opportunity, or can we say, can we get together, you guys and us guys, and go over this plan? Because maybe we can come up with something different. I don't know. I just trying to figure out, or they are just a total authority until the plan is done and then it come to us. I don't know, because last time it came to us, it just came basically overnight and we didn't have time to review it, and we had to vote on it basically, and it's a very large plan. So, and that's why I in the meeting sometimes, because I am there in the meetings, and sometimes you think, oh, this is, and I just don't say anything, because I always confused about the role as a commissioners, as a chair, as three. I don't know what is our role regarding the planning and zoning.
Yeah, that's a great question. So the commission, of course, would have the authority to serve. You're the legislative body, so you're going to be the one that would actually make those decisions on whether or not something is going to be adopted by ordinance and then placed into law. The planning commission's role is to really go through the heavy technical type of items, review things, and then make a recommendation to the commission. So their role is extremely important, and they really should be into the weeds, digging into items and asking a lot of those questions and doing a lot of the research in the background. The commission's role is then to review those recommendations and decide whether or not you feel that they have the merit to be adopted. And whether that's amending your general plan or updating your zoning, regardless of what that is, you would be the one that would make the decision on whether or not you feel that that has the merit to then be adopted.
So if the plan come to us after they are done, do we have a period of time where we can take a look, and if we need more public hearing, can we add to those? Because sometimes
Yeah, it is up to the commission whether or not you guys feel that what is being recommended by the planning commission is ready for discussion, adoption. You simply, as far as public noticing and anything of that nature, that's when you go right to state law, and just to ensure, have we provided the notices in the manner in which they're supposed to be provided? There's going to be a certain amount of days that the documentation has to be available for public review, and that notice has to be out. So those are the type of items that you're going to want to go through and make sure that you've met, and that's before the commission would act on something.
I think what Commissioner Stubbs is asking is, rather than the commissioners wait until there's a finished product, is it okay for the commissioners to get right in with the planning and zoning and brainstorm?
Yeah.
So that their concerns are represented in the
process
of the ordinance.
Sure. Yeah. In fact, I would argue that that's a best practice to do a work session between the commission, a planning commission, and a county commission, to have discussions about that up front. Now, what's important to note in that process is that there would not be anything that could be adopted as you're going through that. So the working session would simply be to ensure that everyone is on the same page, and that you guys are addressing any concerns that the commission may have that they want to make sure that the planning commission is aware of as they are going through their review. So you are the legislative body, and so it is absolutely your right to ensure that you are giving those type of directives and that you're setting that policy tone. But then it's also very important, simply because of the amount of work and engagement that needs to go into that to allow the planning commission to go through the process that they need to go through. But I've always felt that it is absolutely best practice for a city or town council or a county commission to have a working session with the planning commission when you're getting ready to go through a large amendment type of process, whether that's general plan or zoning or all inclusive. I've always seen that as a best practice to ensure that everyone is starting there with good communication and on the same page. I don't know if your process, Mac, has been the same for that in the past.
We've had a work session with planning commission, but it was kind of after the fact. So we've always let planning commission go through and recognize the changes, make suggested changes, and then we bring it for the commission. And that's kind of when it hit the fan in public hearing. And then after that, we kind of reversed and had kind of that joint meeting. We've only had one of them with the planning commission to try to get everybody on the same page of where we're at.
Most of the issues that have gone through the planning and zoning, it had not been a big issue. I mean, it's just approving projects, different things. But with the land ordinance, it's a little bit more, can be more difficult because it's a very large document. And as a commissioner, I have people writing emails, tell me that they're not being heard. Do you know what I mean?
Yeah,
So
absolutely. Yep.
all this stuff. And so to me, it's important if we get together and have a public meeting together where we can hear, everybody can have make sure that, because sometimes we're in the meetings and say, yeah, we'll make this change, but sometimes we don't see the change. And so I think that probably for the public, it would be a good thing for them to see that we are working together.
Sure. Yeah.
And we are listening to them, because in the end, they're the ones going to live in the county. I mean, they're the ones who have to live with the ordinances. And so, anyway, and I think, thank you, because that was a concern.
Yeah, no problem. I think we'll dive in a little bit deeper on that, because a lot of the role of the public in the various processes plays greatly into that, I think. And there really isn't any right or wrong way for a community to address that, because it can be, as Max stated, it can be earlier in the process, it can be later in the process. It really depends on that community's actual process and what they're looking to implement and how they feel that it is appropriate to implement an item. So I've been in communities before where there was a ton of joint meetings up front, a lot of communication up front, and then I've been in others where that was actually held near the end. Believe it or not, I've actually even been in communities before where they never had joint meetings, and it was just the council gave everything to the planning commission. They brought their recommendations forward, and it was actually even quite rare for that council to vote against what that recommendation was, because their process has been in place for so long and was almost a well-oiled machine, I guess you could say, in so many ways, that there was a lot of trust and checks and balances along the way that they felt that it wasn't necessary. So, but it's up to each individual community.
Commissioner Harvey has a question.
Just for clarification, when there is commissioners attending the Planning Use Authority Board or the commission, typically commission members aren't participating as the commission body on actions and businesses, but are more maybe on the public end, participating in input and not the decisions, just input and such, correct?
Yeah, that, and I will say that can certainly be a gray and very challenging type of area, simply because of just the perception that can come along there. As a commissioner, a council member, anything of that nature, when you're then attending any other public body meeting, of course, there is going to be the understanding that there is a legislative authority within the room, right? That there's an elected official within the room. Oftentimes, for the public, that then gives them a misunderstanding about what their role and both their role as the member of the public and the role of that elected official in the room is. And so I always urge caution with any commissioner or council member or anything of that nature attending those other meetings. You are obviously members of your community, and you absolutely have the right to do so. But it should be done with caution and care to ensure that it isn't inadvertently making it more difficult for any member of the public to understand the process, or to maybe even confuse them into thinking that you have the authority in that meeting to take some type of action where it would not be appropriate for the commissioner to take an action in that meeting at that time.
Very good.
Does that make sense?
That helps clarify, because ultimately, in my mind, it's common practice that we allow the commission or any board to have that independence in making the decisions in their meetings.
Mhm.
And then when we finally come to approving it, we're the commissioners who would review and make the final approval.
Yeah.
It's that kind of relationship.
And I've seen many, many instances where, when it does then get to that point where the decision, now the legislative decision, is before a commission or before a council, that members of the public will point to something and say, that commissioner has a conflict of interest already because they've been engaged in steps A, B, and C. I feel that they manipulated the process into something they either did or did not want to see, something of that nature. So, as I always urge caution for commission members when they're going to engage in those items. And unfortunately, that is just part of the system and part of the actual process. And being an elected official is then all of a sudden, yes, you certainly have an enhanced role and ability to make impact within your community, but then there's also areas where I don't want to say rights are taken away, because they're certainly not, but you have to be much more mindful about how you are engaging in certain items, just because of the perception and complication that it can add to a process overall.
So, quick question, if I may.
Mhm.
So when you mentioned that having the work sessions between the planning commission and us,
Mhm.
would that need to be a public meeting, or just technically it's a work session with no decisions made, of course.
Correct. Yep.
So it's just the conversations back and forth.
Yes.
Without public notice, or would it need to be? I mean,
It would be similar to like a planning commission meeting,
Yeah.
right? Open to the public.
Mhm.
But again, working session with no decisions being made, there doesn't need to be noticing to the point of any type of action is going to
Sure.
be taken. But the meeting does have to be open and available to the public.
Okay.
Yeah. So any type of government meeting in the state
Yeah.
of Utah needs to be accessible for someone to view what is happening within that meeting, minus any type of item that fits within the appropriate section for a closed session meeting, right? But those items are very specific for closed session.
I have another question. So would that include being online, like we are online? Just for me, it's just I have never been in a position like I am as a commissioner. So I attend the planning and zoning, and I always am here as a citizen because I wanted to know the process, because when it came before me, and this is before, had to do with permits and everything, trying to learn the jargon, trying to figure out.
Mhm.
And so, and that's my role. And I always, and I don't make comments, I don't say anything, nor have meetings with the planning and zoning outside, because that can be another thing that we can be doing anyway. But so So as long as we don't participate, because I'm a property owner too, so I can
Sure.
be in the county. So, but anyway, I just wanted some clarification on.
Yeah, again, it's just an area where I would always urge
Yeah.
caution. Once you become an elected official, my recommendation, obviously you're still a property owner, you're still a member of your community, you care about what's happening in your community, what items are being approved. I find it best practice at that time, once you become an elected official, to then have much more of your communication directly with staff as opposed to attending public meetings. And staff can make sure that you understand what the process is for any type of item. Say if there were a conditional use permit that you were interested in and that's going through the planning commission process, then you can have communication with staff and they can make sure that you understand, here's the process, the conditional use permit process, here's the steps that it will go through, here's the agendas and the items that are associated with this, and then you can monitor how that's going through that to understand the process. And if you have concerns, as a member of the public, you could still submit those concerns to a staff member, is what I find being the best practice there, as opposed to attending the actual meeting. The reason why I give that recommendation is because oftentimes that can end up confusing members of the public on what your role is.
And I guess we always can watch the video after the meeting.
Yeah, absolutely. Yeah, definitely be engaged and aware. And
Well,
I mean,
with me, I just want to learn what the terminology and all the stuff. So
yeah, utilize staff for that once you go to elected. And again, the recommendation there is to try to avoid as much of the perception of any type of conflict as possible, which serves as a protection for your agency.
thank you.
Okay, so and speaking of, I think this ties right in very directly to what we've been discussing here. There is a very important difference between legislative decision making and the legislative process, and then administrative decision making and the administrative process. I would argue in all my 20 or so years of planning that members of the public are most often confused and frustrated by the difference between these two items and a lack of understanding about what their role is in a legislative decision-making process and then an administrative decision-making process. And oftentimes members of the public will come out with terms such as, they didn't care what I said, they weren't listening to me. 99% of the time, that is an administrative process that they were going through, and there was not understanding of what that meant, what the role of the public can be, and the agency that is taking administrative action, what their role is. And so we're going to go over a little bit of that. So legislative decisions generally involve making laws of general applicability, right? This is what the county commission is typically going to be doing when you're making these legislative decisions. You will base all of those decisions on weighing a broad and competing policy considerations, as we'd previously discussed. Some of your typical legislative decisions are going to be things like the adoption or amendment of your general plan, enactment and amendment of any land use ordinances or development standards, enactment of your zoning map, approval of a change of zone, anything of that nature, annexation decisions, right? Any change to your municipal boundary in any way, those are going to be legislative type of decisions. Considerations when you're making legislative decisions, first and foremost, you'll note that everything, of course, can't violate applicable state or federal law. That sounds scary, but that's why you have an agency attorney, right? So that attorney, of course, will let you know first and foremost if there's anything that appears to be in conflict there. Oftentimes, that sounds a lot scarier than it actually is. But certainly, you have your attorney in place to ensure that those items are going to be addressed up front. Second, it's important to note that if it is reasonably debatable, and the reason why that's in quotations is because that is the actual language from state law. If it is reasonably debatable that the decision could advance the general welfare or public interest and it is consistent with the State Land Use Development Management Act, then a court is likely going to uphold that decision as legal. The reason why I point that one out is because courts in the state of Utah give very, very broad discretion to local agencies to make their own laws, to set their own rules and regulations, as long as they're not violating existing state or federal law, right? Once you make those rules, then the courts are actually going to flip to the other side, and they're going to give more deference to the property owner. But up front, they're going to give very, very broad flexibility to local agencies to make their rules, to set their rules, to set their laws. It's important that as you are considering any of those laws, the legislative body should attempt to strike an appropriate balance between the public interest and those private property rights whenever there's a conflict between the two or any type of rub, and they're simply not aligning there. So legislatively, you have very broad authority to set or even amend rules that are in place. Now, what is the role of the public in the legislative decision? And as I'd said, this between legislative and administrative is where I think the vast majority of public misunderstanding and frustration comes in. So the legislative body should and absolutely can take into consideration input from the public, and that means from property owners, anybody that's interested. Doesn't mean they have to be a property owner. Doesn't mean they have to be a resident, in all honesty. Anyone that is interested and feels that they need to give feedback on any type of project in any way has the right and the ability to come forward before the commission and have any type of discussion when you are talking about any of these legislative actions. That can include things like their preferences and their opinions, right? But then it's up to the legislative body how much weight you want to give to that feedback that you've received from that individual or those individuals on that item. So how much weight are you going to give to that? The legislative body should also always seek to receive input from public for the purpose of gathering facts and evidence on any type of item that's coming before you, right? The stronger of a record that you have in place on why you made a decision or why you took a certain direction on something, the more likely you are that if that item is challenged, to have the support that you need and the understanding in place for that item, that action to be upheld, or a challenge that comes against that to not be successful. So then administrative decisions. So administrative decisions are going to involve applying the existing laws, the existing codes that are now in place to a particular development proposal. And those are going to be based upon the individual facts of what that project or that proposal are. So typically administrative decisions are going to be, and this is newer in the last couple of years in Utah, subdivisions for single family, two family, and townhome. Those used to be legislative. Those are now administrative. Conditional use permits, site plans, building permits, variances, things where it's very important to note that you have already set the rules in place. You've identified the policies, you've set the rules, and now it's the administration's job to apply those rules as items are coming in and coming forward. So the considerations that you need to take into account when you're making administrative decisions, again, can't violate state or federal law. That's always going to be that foundational item. But the land use authority should look to apply plain language of land use regulations to every land use application. It can be very challenging when you're involved in government items and government documents for things to kind of become that government speak, right? And it might not make as much sense as something in plain language could make to somebody. So always try to make sure that you, when you have your applications and things before you, that there's as much plain language there and things that certainly have a level of clarity for any member of the public that they could understand what they are.
Can I make a comment?
Sure.
You know, I have been visiting many county sites to see what they have in place. And that's one thing I noticed. They're very simple.
Mm-hmm.
Very simple. Very few pages in the land use. And they're very simple, just almost one paragraph or permits, different things. And I thought, I can see that'll be easy to vote on, you know, because you can understand it's, I don't think there'll be many questions from the public because it's just a simple set. And so I was surprised to see how simple many of them were.
Yeah.
Just half a page, some of them.
Yeah, and that's I think that's a good thing, right? As much of that specificity as you can have without having to have too much language that can be really confusing and convoluted for people. I think that's a very important thing. Yeah, so I'm glad that that's been your experience because a lot of agencies that's not.
I decided to go check on, especially on smaller counties, and you know, like I said, I was surprised. In some, you know, even with the general plan, everything was just very simple.
Yeah.
And they have been there for a long time. Some have not been lately updated, and so
That's good.
anyway, but
Well, I'm glad you've seen that. I think that's very important. As you're going through the review process, one of the most important items that needs to be understood by those obviously making the administrative decisions, but also those that are making those policy decisions, the legislative body, when you are looking to put language in and to adopt language, understand that if a regulation does not plainly restrict a land use application, or it could reasonably be read to support a different interpretation, the courts are typically going to side with the property owner. The reason why is because the state of Utah is a very strong private property rights centric state, right? They believe that you should have maximum use of your private property. So unless there is a regulation that makes it very clear that a certain item is prohibited, then someone could come forward and argue this is not prohibited, that courts are typically going to side with the private property owner.
Can I put you to the test on that point?
Sure, yeah. I mean, there's no such thing in land use that's 100% of the time, right? That's just the general theme.
This is an actual situation here in our county. So we have a Love travel station that wants to go in just south of north. Under the old ordinance, gas stations, restaurants, repair shops, the normal stuff that was in existence in 2000, a long time ago, they're all specifically approved. Travel stations, which I view more or less as a combination of those, is not specifically approved. So how would you feel about, would it be reasonable for the planning and zoning to say, you can build the restaurant, the auto repair, the gas station side by side, why couldn't you put them together as one?
Yeah.
Do you feel like that's a reasonable approach?
I mean, reasonable to one person may not be reasonable to another person. I can certainly tell you, if someone were to come in and challenge that item, that there is precedent that may be a successful challenge, that they would likely be able to say that.
The
Yeah.
office has an opinion on that.
Yeah.
The statutory scheme's a little different. But anyway, I was thinking of that when you were going over this, so I thought I would just.
And it is going to be specific, of course, to that agency as well, because every agency has a little bit different language, right? So that's not something that you could say, hey, a court every single time is going to side this or is going to side that. It is going to depend upon the facts of the case, the adopted ordinances that are in place for that agency. But the general theme there that you will see with the courts is that there's going to be more deference on the side of the property owner for use of their property, as opposed to limiting what that use is, in general. But that is not a hard and fast rule for sure.
Thank you.
And it's always important for that land use authority to support their decision with substantial evidence. And you'll note that multiple times through the presentation, I've talked about the record, right? You always want to make sure that you have as much in the record as possible, so that if you do receive a challenge on something, that you're going back to the record, because the courts, that's all they're going to take into account is what is on the record of how this decision was made or how this policy was adopted or whatever it might be. They're going to simply look at the record. They're not going to take preferences and opinions and public clamor. They're not going to take any of that into account. They're only going to take into account what is actually on the record. So it's very important to make sure that you have as much evidence as possible.
So something interesting about that, though, with that example, is the fact that this, we're saying the state leans more toward the property owner rights. So
The law does.
Basically, yes, the law. So we have private property owners that are crying out about their rights as property owners, but this individual wants to use their property to the maximum of their property rights.
Yep.
But there's a direct conflict with both. I
Yep.
mean, they are bashing heads continually. So it's like, where does the law land? I mean, we're trying to exercise that right for both property owners.
Yeah, fully
You know what I'm
understand.
saying?
Yeah, and that is the consistent challenge with planning items at all,
Sure.
and that's because a decision here impacts the people that are around that decision and potentially other impacts down the road as well, right? So there's never going to be any type of land use decision that's going to be made that is going to be viewed by people as unanimously that's exactly what should have happened. And that's because everybody has a stake not only within the community at large, but obviously within their individual properties as well, right? So that's the biggest challenge for the legislative authority, is to consistently try to balance out what those items are. That's where it becomes so important for substantial evidence and for when you're going through your policy discussions and decisions to make sure that you have done your very best to have that type of forethought and understanding of certain things being allowed or prohibited. Here's the type of impacts that they could have and the likely challenges that the agency may have to deal with, moving forward with those items. So there is no such thing as perfection in planning and in land use. And I would argue that there's never any such thing as rest either, right? Yeah, there's always going to be consternation.
Especially, as commissioners, we sometimes fixing things that somebody decided a long time ago and the records are not there.
Yeah.
Word of mouth, gentleman's handshake, and we try to interpret what was their thinking. And so because we change often, I guess it's the reason more and more important to be clear with the records. So
Absolutely. Yeah. Thankfully, in today's world, we have more ability to keep record, and to have more record as with less challenge, I would argue, than what it was in the past. When I started planning, I can remember the city clerk sitting there with the cassette tape and then doing the minutes the next couple of days, right after each individual meeting, and pause, play. I mean, and I just felt so bad for them as they were going through that. Now with things being digital and online, and now even new tools like AI that can do a lot of transcription for you or can assist with a lot of those items. There's a lot of really good tools in place that can further support that body of evidence and information that you have for your record, which is a great thing. But yeah, it's so common for commissions and councils to have to deal with things that don't have record. Yeah. And especially like you'd said, the handshake deals, or that's not what I was told, and there's no evidence one way or the other, right? And you guys get to be the ones that get to balance all that out. You get to weigh all of that broad and competing information, and how much weight do you want to give to something. And so it's never easy, for sure. Never
so
easy.
These two slides kind of split a difference, because you have, so if you go back to the previous slide, I see that more of a staff, so administrative decisions
absolutely.
Staff makes. But then on their, so these are what staff can handle, your subdivision conditional use permits, without having to go back to planning commission, who's the land use authority as well. So in that, if you forward to your next slide, now you're on the substantial evidence. So if it doesn't go through planning commission, is it wise for staff, as they approve a conditional use permit or a variance or a subdivision, do they have to have that substantial evidence as well?
Best practice is yes. Substantial evidence in those instances is going to look different than a legislative decision. And it could be just simply a checklist of, here are the items that we have to go through, and a staff member checking these items. This meets all those boxes. That then is your evidence. Why was this approved, or why was this denied? And it's, well, here's the checklist. We have these 10 items that are required through administrative approval process, that it has to address these, and it checked all 10, therefore it was approved. Or it did not check some of these boxes, and therefore it could not be approved. That could end up being what the law would look at as substantial evidence.
Okay, I just wanted to par those two.
Yeah. The way that I always look at legislative versus administrative is, legislative is making the rules, administrative is then applying those rules, right?
Okay.
And regardless of whether you agree with the rules or like the rules or anything, they are what they are. And that's the only lens that's then used to look at an application that is before you. And that's why administration or administrative decisions are much more about implementation and checking the boxes of what the rules are. Yeah, it's very, very process related, whereas legislative is setting that process.
Okay.
Okay, so The role of the public in administrative decisions. Now, I know I've already touched on it, but I will say again, in all my 20 plus years of planning, this right here is the area where I have seen the most members of the public get very, very frustrated with the process because there is a lack of understanding here about what their role is in an administrative process. So first, the Land Use Authority cannot rely on public opinion or preferences when they're making an administrative decision. Now, you'll note that's different. When we were talking about legislative, opinions and preferences absolutely can be considered by the legislative body, right? But they can't be considered when you're making an administrative decision because the rules are already in place. So a very common example that I have seen before is if someone were to come in and say, there is a convenience store that is looking to be located in this area right here. It's going to require a change of zone. It's currently zoned industrial, but it needs to be commercial, or it's residential, it needs to be commercial, whatever that change might be. Somebody could come in and they could say, I don't like convenience stores. I don't want a convenience store there. And I don't think that the change of zone should be approved to then accommodate that type of development. The legislative body, because any change of zone is going to be a legislative decision, can take that opinion and that preference into account. Well, Citizen X that's standing right before us right here just said they don't like convenience stores. And you know what? I tend to agree with that. Therefore, I don't think that we should approve that item. However, if you then were to say this is an administrative decision and a person is coming in for a building permit, say that that same exact lot is already zoned commercial and that convenience store is a permitted use within that. So if they're going to be coming in and they're doing either a building permit or even if they're getting a conditional use permit, because say they're going to have a gas station associated with it and a gas station requires a conditional use permit, the planning commission, as they're coming before the planning commission, is going to be acting in an administrative role. And so it's going to be, can you check the boxes of what the rules say that you have to do? And if they can, then that should be approved. If they can't, then it shouldn't be approved. But note that the rules are already in place, right? So a public opinion or a preference, someone coming into a planning commission meeting and saying, I don't like convenience stores, or I don't want a gas station there. If it's already zoned appropriately for it and it's just administrative process that they're going through there, that administrative body that's taking the administrative action there, they can't take public opinion or preferences into account. The rules are already in place. They've already been set, and those are the rules that are being compared against that specific application. They can, however, and I would argue always should, seek input from the public for purposes of gathering facts and evidence, right? So if that same member of the public were to come in and say, I don't like 7-Elevens because I think Slurpees are disgusting, so don't approve that one there, that can't be taken because that's opinion and preference. But if they were to come in and say, 50 years ago there was a certain use there, and I believe that there could actually be pretty significant contamination to the soil in that area, that could be a fact-based evidence type of item that needs to be looked at and considered, right? Is there something environmentally that needs to be assessed or understood there? Or most commonly, you'll hear someone saying something like, I don't know if you guys are aware, but there's actually an irrigation pipe that runs right through that property right there. And I'm not seeing it on any of these maps that are being presented right now for this conditional use permit. So that could be another item where it would be, that's fact-based and evidence-based. We need to find out, is there in fact an irrigation pipe that is going through there or some other type of infrastructure that is not being appropriately notated here that we need to make sure is understood, right, before we move forward on anything. However, the vast majority of the time when members of the public come in, I would say 99 times out of 100, they're giving opinion or preference on something. The opinion or preference can't, at the administrative level, make a difference on the decision that is being made at that time. Members of the public rarely understand that because to them, this is a public meeting, and that's kind of where their level of typical understanding as an everyday citizen comes in, and they think, there's a public body, public meeting, anything that I say they should be able to take into account whether I like or don't like something. And when you're talking administrative decisions, they can't. So my recommendation is for planning commissioners to make sure that that is communicated in every single meeting, that there are rules and procedures that are in place for them and that there are certain things that they can and cannot act on. Or cannot respond to even in certain instances, to make sure that the members of the public that are attending there have that level of understanding. And oftentimes that can help. It's typically not going to take away their frustration or even their distaste if something is approved that they don't like. But hopefully the effort to be transparent and to have good communication there can make a difference. Okay. So I have a few slides here that are just additional planning basics. I'm at my hour right now, so I'll just kind of skip through these really quickly. And when I say skip through, just kind of go slide by slide. And if you have any questions, you could let me know. Yeah.
I was going to ask this at the beginning, but I thought
Sure.
I'd let you get through. So, in our county right now, as has been mentioned, there's this ordinance that's in the works.
Yes.
And during that process, there was mention that, hey, you should update your general plan for land use as part of that. Do that and then do the ordinance, because there's been a little time since the land use portion was updated.
Sure.
One of the questions we've had is, how to go about that. I guess I'm asking for your recommendation. The county has more money than it knows what to do with, right?
That's a nice problem to have, yeah.
That's what everybody
So-
thinks.
Of course, right.
Your expertise is appreciated and it's really helpful. We've thought about hiring an expert to help us with the land use portion. But we know there are resources out there that wouldn't really have much of a cost. And so I'm just wondering from you if you feel that hiring an expert is on the side of a necessity versus a luxury, or how would you come down on that question? What do you feel we should do?
In my opinion, that's really going to come down to the scope and scale of what you're looking to do.
This is just the land use portion of the general plan, so it's fairly
3 pages.
A little
right now,
little more
it's about
focused.
3 pages. It's a small portion of the overall.
If I were a staff member or even an elected official here, my recommendation on that would be to start with those resources that are at CERTA.
We
Where
already have contacted them.
has there been any
Serve on
communication?
board.
Okay, terrific. And then work with them to see what is within their capacity to be able to address for you. And if there's something that you need that goes beyond the capacity that they have there, then you could certainly consider whether or not you're then looking for any type of consultant assistance. And it's not uncommon for the local administrative advisors and the technical assistance planning positions to also have some of that additional support that they're working with like that.
Does one of the phases of this, of course, is the public input.
Mhm.
And so, I believe in some cases, a third party will help run a meeting,
Sure.
gather information, and document it and help with, the summarizing of it and so forth.
Yeah,
so that
absolutely.
It can be incorporated. I think the county has the ability to do that as well, but I'm just wondering, sometimes with the public, in a small community like this especially, everybody knows everybody. And so do you feel that a third party being involved lends more credibility and deemed more unbiased and so forth? Or do you feel like, just do it as a county?
I've in all honesty, I've seen that go both ways. I've seen where a third party consultant assistance has been able to come in and help facilitate some really good conversation and communication that may not have been able to happen organically. But then I've also seen instances where an outside party comes in and they're looking to try to help, and they're actually seen as you're an outsider. And any of your input here is seen as invalid and even unwelcome. So a lot of that, I think, is really just going to come down to your guys' understanding of your community and what you feel is best in the approach to take. I would just recommend that you guys certainly leave the consideration for any of those options open, and whichever one you feel is going to best work for your process. Then certainly be willing to take that step forward. But I think my biggest recommendation would certainly be to make sure that you are having good engagement with CERTA, because there is a lot of state resources that can be utilized at the local and regional levels to help individual communities. So there's a lot of dollars that you don't have to take out of your budget that are already allocated at the state level to seek to assist with these exact type of processes here.
So can I clarify something. You said the general plan, we're under the understanding that the general plan has to be updated prior to the Ludmo. But in the state of, my understanding from what you said is that is not required with the state of Utah.
So the state of Utah is not what's called a consistency state, right? So there isn't a requirement that your general plan and your zoning have to have consistency when you're making a land use decision. However, the best practice of that is that the two should be consistent. And the reason why I say the best practice is because if you have instances where your zoning and your general plan map do not line up, that is so incredibly easy for somebody to point to that and just say, I'm going to challenge any decision that happens there. And the courts are likely going to say, you have conflict within your own local documents there. And they're traditionally going to side with the challenge that is coming before on that.
Which, yeah, I don't disagree with that, and that's what the process we're in and what we're trying to do. It's just the minute we were working on Ludmo, then it's, oh, well, we're just going to sue you because you're not doing the general plan first. So, I mean, I can see where that, but there's obviously a few more words in there that needed to be explained.
Yeah.
To make that a little
and they can be done concurrently as well.
Yes,
It's not uncommon for an agency to say, we feel that there needs to be changes to our land use map
Sure.
and to our zoning, and therefore we know that some of those desired changes are going to conflict with the general plan, so we're going to address them concurrently. You can absolutely do that as well.
Okay, thanks.
But I would recommend, even though it's not required, I would recommend as you're going through that process, even if you're doing them concurrently, that you would take action on the general plan first,
Right.
and then have your ordinances right behind that, like your mapping right behind that.
So, okay, thank you.
Okay, so unless there's any other questions, these really just cover a lot of the common type of questions that we get: variances, conditional use permits, exactions, things of that nature. It doesn't sound like that's anything that you guys have
I think the
likely questions on right now.
Monica, we are having training for the planning and zoning also.
So yes,
This-
planning and zoning, we have them lined up for next planning commission
Okay.
meeting for.
And it'll be the same type of
Yeah.
training that I'll deliver
I
to
think
them
it's-
for consistency.
There
Yeah,
should
I
be a
knew
little
that we had
2-hour
talked about
jaunt
having that
instead.
because they do supposed to be having some amount of training, planning and zoning.
Yeah, they're
which
required four hours a year, and one of those has to be on rights and responsibilities. So by default, this one covers that. And as Max said, that'll probably be closer to 2 hours. The additional slides that you saw there, because oftentimes planning commissions are either dealing directly with those items or they're heavily involved in them and need to understand them.
Yeah.
Their training usually goes about an hour and a half to 2 hours.
So, okay. just
Yep,
wanna
and then
make
this
sure-
last one right here, this is what we just call our Jeopardy slide. Kind of gets to I would say these are the most hot button issues here. So if we had more time and there was anything there that you guys had questions on, we could address them in this meeting. I don't think we have more time today, but if there is anything, I'll make sure that Mac has a copy of this presentation so that you guys can have that on file. And any questions, concerns, anything
Can
that
we
you
email
have,
Can we contact you?
absolutely. Yep.
Okay.
Yeah. Reach out to me or reach out to Mac if you want to ask the questions to him, and Mac and I can work on
Yeah.
getting you guys appropriate responses.
How much, and this isn't to be offensive to Jens or anything, but how much involvement do you see in other places with the county attorney being in the meeting and a part of the meeting? Some of them, and I spoke to Jens about this same thing, it seems like if the attorney's there, oftentimes they will focus their attention on the attorney's interpretation rather than the planning administrator or the planning commission interpreting it on their own. So if you have the legislative body already passing the ordinance, then it's up to that interpretation, which is typically what the planning commission would deliberate on.
Yeah.
But with our county attorneys, they seem to like, okay, county attorney, give us your opinion right now, right here.
Yeah. Yeah.
You know, and Jens is kind of stuck. Was like, oh, let me go through, and he's. I mean, both of us behind the scenes are kind of trying to go through LUDMA and also our ordinances to make sure we interpret that right. Is it better to have them not in the meetings, or unless it's a contentious item that we know going forward, bring the county attorney in, or do you have the mayor present every meeting?
I mean, that it's completely up to the agency, of course, and it really is more of a stylistic item. I can tell you that my personal preference over the years has been to not have the attorney present at the planning commission meeting unless it is something we know has been contentious, or if we are to the point in a process where we're making a recommendation on something major, like a general plan amendment or something of that nature. The rest of the time, we simply did not have the attorney there, and that's zero disrespect in any way, shape, or form to the attorney. It was for exactly what you said. It was because there's the administrative process, and this is the way that we are interpreting these items administratively. And then, if someone had an issue or a concern with that, we would reach out to the agency attorney outside of the meeting to have additional conversation. Yeah, that's how we had dealt with that. So I have found that to be very effective, but it's completely up to the agency and how the agency feels that they want to address that.
Ours have been hot buttons, and so
Yeah, so
they've been needed.
So maybe
Yeah,
they,
it might be
they
good.
ask you questions.
They do
at the
all the
end, like on the
time.
really hot items.
Yeah.
They definitely do. So.
And, legally, there's very rarely cut and dried type of answers, right? The vast majority, especially on land use related items, is, I had a professor in planning school that actually said to me, the term that you need to get most comfortable with as a planner is "it depends," right? And I can remember as a college student thinking,
Like, what?
what? And then getting into the profession and realizing, oh my goodness, it's almost every single question that you get, the answer does start almost with, well, that depends, because we have to reference what policies are in place and what zoning is applied here, what precedent is set, what does the general plan say, what does state law say, right? And every situation is going to have its own little potential subtle nuance, and that can make all the difference. So yeah, oftentimes the city attorney getting asked questions like that, and of course they want the answer immediately, right? Because
Yeah.
you got to run the index in your head because you have everything memorized, right?
Get it wrong.
Yeah, that's how they look at it. Yeah,
Fast, get it wrong.
yeah, it's very challenging.
So you'll email your slide deck.
Yes, absolutely.
Okay.
Yep. And then if you guys have any follow-up questions, or even if there is, hey, we would like an additional presentation, additional training on something more focused here, or we have concerns about this, let us know. I mean, that's the entirety of the reason why I'm here, and always happy to be right in front of you, or even if it works better for a Zoom, something remote, whatever you guys need, we're going to make it happen.
Thank you.
Yep.
Thank you.
Appreciate the opportunity to be here. Thank you so much.
Thanks.
Thanks, Rob. I appreciate that. That was awesome. That would be helpful. We'll see you in a couple of weeks on the planning
I'll be here.
commission. So let's see. Let me jump out of here. So the next item, you have Airbuild Incorporated, just infrastructure pods, John Buckner, Elbid, Fields. So you have Reagan and Talia that are going to present this item here. Hopefully they're running down the
Get
hall.
that attachment. Was there an attachment? I couldn't get it to open.
Oh, it's not popping up.
I could not. Get
She
it.
had sent me an email earlier.
Mac, do you want to eject the
Yeah.
What's that?
Do you want to eject the thumb drive?
Yeah, go ahead. You're all ready.
Thank you so much.
Thank you.
Hey, thanks. Appreciate it.
Bye-bye.
Did you get my email, Mac?
Did I get your email? Ooh, yes,
Just the
maybe.
presentation.
So I have a short presentation and a short city and a San Juan deck. Which one do you want?
Short.
City.
Short city?
Yeah.
Reagan's a coming.
Okay. Here we go. That is what it looks like on the screen. If you want to control the mouse, or
John, do you want to control it?
Yeah, where should I stand?
right there at the podium is fine.
Cool.
So,
I can do
I
a
don't
quick
need I don't need
intro
to
if you
control the
want.
mouse. I can just give someone a cue.
oh, that's fine. It's
Yeah.
right there.
Cool.
Here, I'll do a quick intro for you.
Oh,
too,
okay.
Just so you know. So we're waiting for Reagan too, but thanks for letting us take some time to present. Through economic development, we've been kind of looking at business development, workforce development, and kind of the infrastructure that we need as a county when it comes to different layers and industries. And agriculture has been one of them, as well as energy. And we're looking for companies or solutions to some of the problems that we have in the county. So AirBuild is going to do a quick presentation, but what we'd like to do is see if we can do some partnerships with them, because one of the challenges that we have is whatever we bring in needs to be able to do multiple things, kind of the way all of us wear multiple hats. And I want us to be really innovative. So in the agricultural sector, what we originally were looking for was, what can we do for water purification? How do we do soil remediation? And also what are our needs that we have. And so I've been working with USU Extension, with just Reagan, to come up with some solutions that we have. And what we're really interested in is that AirBuild offers help in all of those areas, as well as solar. And so I asked if he would do a presentation for you guys so you understand. And then later on, we're looking for a letter of intent, just that we can look at project areas, soil, and kind of explore what that could look like in our area. It also offers an opportunity for workforce development, in that it's a new technology, and the combination of what it is. And we could specialize with apprenticeship programs for the technicians. My hope is we can partner with either USU or develop a separate apprenticeship program if it came in the area. But what's unique about it is, if we're able to spread it across the county, it would actually provide jobs over in where like the chapter houses, that they would be able to have jobs that they can reach, which I think would be very valuable, and then throughout where we're at. And I will let him present. Do you want to add anything, Reagan, to that? Okay, that's all right. We can do after.
Hi, everybody. Excuse me if I stumble. I haven't been in a room like this before, so also I feel like I got a traffic ticket right now. But anyways, my name is John. Thank you, Talia, for introducing me. I'm with a company called AirBuild, and we've been around for 5 years now. We do research on algae, and we started this company to use algae to clean water and clean the air through what's called carbon capture. So we got in Utah in a very peculiar way. We're actually based in Green River, building the first AirBuild plant right now. And it's a smaller plant, and we plan to scale it up to 12 acres. But economic development in Utah introduced us to Talia. And when Talia told me the story of San Juan County, I realized that there's so much opportunity for us to do what we've done in Green River, because a lot of the same problems were emulated. So in Green River, I'll tell you guys, if you guys are probably familiar with Green River, but the water is so polluted and it has E. coli everywhere. It's not exactly drinkable, to the point where, me being a resident of Green River now, I get letters in the mail saying that you shouldn't drink the tap water. We are installing the AirBuild system to use microalgae to remediate the water. It pulls toxins out, it pulls nutrients, pollutants out of the water, nitrogen, phosphorus, and what we do is, when the algae grows, we process it. So the algae basically sucks up all of the gross stuff out of the water. We process it through a process called pyrolysis into biochar. Green River is an agricultural community, so biochar is a charcoal that is extremely dense in nutrients. It has nitrogen, carbon, phosphorus. It's basically a replacement for fertilizer. So we create a circular economy. It's an economy that takes pollutants and carbon and a bunch of negative things, and it turns it into something positive. And AirBuild makes money off of selling carbon offsets to Microsoft and Taylor Swift and people like that, because algae also removes carbon from the air. So in Green River, what we're doing right now is remediating the river. And then through our research, we found that it's also a wastewater treatment supplement, because algae is extremely powerful. So they have sewer lagoons right next to the river. And for the next phase, because of our numbers and research, they've asked us to actually connect it to the sewer lagoons. So the options for how we can help San Juan County's water and soil situation is actually endless, because we can set in stone or set in motion a circular economy for getting this done. Not a big presentation guy. I made this just so you guys have it, but if you'd like, we can kind of run through it. I know that I gave my spiel. I'm actually happy to take any questions.
Do you mind if I step in here?
Yeah.
If you guys have questions about the system after I'll just kind of close up what Talia.
We did have a presentation before. The people from Arizona came and
Yeah, so
Yeah.
he
It's a
was,
Zoom
Yeah.
call, wasn't it?
yeah.
so we started that process, so we've continued, but I'll let Reagan kind of why
Why
we
this
really
is
pursued
important.
it.
The ag side. I'll give you the ag experience.
Physical pictures, like the site, what it looks like and everything too.
Green
this
River?
presentation.
Oh my gosh, I should email them right now.
I'll give you that.
Yeah.
Okay, so Talia and I, we started like after she started with the Economic Development Office, we really started to connect. A lot of the funding sources that she was finding was for food security, a lot of things related to agriculture directly. So her and I started connecting. We kind of just meshed because I have a lot of visions for the county and what we're trying to push forward in some of our programs. I have been
Could you just tell us what you do for the ones that probably don't know?
Yeah.
How great
yeah.
stuff you're doing.
Okay, so
She's gonna
we'll
change the
start
land.
going into that. So I've recently, over the last, it's probably been about a year, I've been starting to go into a different alleyway of practicing agriculture that has been heavily science researched, but is not like the popularity norm, and it's what we call regenerative agriculture. So what that looks like is looking first and foremost at the foundation of what we are all using, what we're standing on, which is our soil, and looking at soil health and what that means to actually have healthy soil base that's giving back to you, and how you start giving into the soil. So our current agriculture practices, and not to rip apart any of our producers, because it's been a common practice that's been carried, worldwide for histories of years, is heavy conventional tillage. And what's been sought and found is that heavy conventional tillage causes compaction, and then it doesn't have any life in the soil. And what we mean by life is microorganisms. So we have microorganisms that are abundant everywhere on every surface. On our skin, we have a skin microbiome. The soil also has microorganisms living inside of it abundantly. A lot of our illnesses, and like what we're coming through now, is illness in the fall is going to start spiking up. Why is that? We have, temperatures decrease. We have different microorganisms that thrive. We might be working in the soil. Maybe dust starts blowing, and it's the dust in the air that actually carries most of our common pathogens that cause illnesses. Okay. And so we have a microbiome in our soil, and how do we cultivate that? What are we looking for? What is healthy bacteria? We also look at what is healthy fungus, believe it or not. So those are the largest leading groups of species that we know in this world, and we don't even know more than half of them. We only maybe know about 5% of the fungus and the bacteria that we have in our world. Okay. The fungus, a majority of fungus is actually very beneficial. Same thing with bacteria. Anything that causes illness to plants, to livestock, to people is probably about the lesser 5% of what is actually existent in our world. Okay. The ones that are beneficial actually help control your pathogen leading species. Okay. And so what we want to cultivate is a soil microbiome that can help create more balance. And some of the ways to do that is through biochar. Biochar creates a place for beneficial organisms to be able to live and thrive. We are working with the Conservation District. They've actually got a no-till drill to start practicing reduced tillage or minimal to no tillage, because the more that we till, the more that we actually, again, it causes compaction. So we get more less oxygen in our soil, less avenues for water to permeate, and then you get just a pure bacteria circumstance where the bacteria that thrive on no oxygen are your decomposers. They're your pathogens. And that's what we're cultivating in our soils every time that we till for the long history. If we start to cultivate an environment where we have fungus that helps fluff our soil, good bacteria that love oxygen, and we start supporting an ecosystem where we can break compaction, we can get oxygen into the pore space, our soil will actually start receiving water instead of repelling it. Right now, we have a lot of hydrophobic soil. So the water hits the ground, it doesn't even have an avenue to soak in. Instead, it's more so running off. And that's what we're seeing with erosion. So there's lots of ways that you can do regenerative agriculture, leveraging animals to graze on the landscape is one of them. Not overgrazing, but not undergrazing. So they have to be able to graze and go through and start. They also inoculate the soil with their fecal matter, which is what we want. We want beneficial bacteria. So a lot of your ruminant animals are very supportive of and what is used to leverage in regenerative agriculture. We can give resources about regenerative agriculture. This is actually being done. It does take years to be able to repair the soil. Biochar is definitely one of those methods to begin repairing the soil. Again, adding a place for microorganisms to be able to come and have a home and start actually working and leveraging and repairing the soil. We actually have a workshop that we're going to be, I will be presenting at for September 11th and the 13th. We would like to invite you guys so I can bring flyers for that. We do require registration. If you guys let us know, we can give you the code and we can definitely support the cost of your meal. That's all we're charging for is for lunch on either day. And it's the same instruction where you can learn more about what I'm talking about. And it's part of these programs that we're starting to push out. And it ties along very well with AirBuild because we're trying to find and source avenues of how can we get more of those nutrient resources back into the community. And I just kind of want to add that we started going down this pathway when prices for fertilizers started going up. You know, they're 3 times over the price that they were pre-COVID. And our producers even today, or even back then, struggled to even afford fertilizers with the circumstances that we had. So fertilizers now are out of the question. What are we going to do? How are we going to support our producers? I had a freelance writer from Washington, D.C. reach out to me several months ago in the spring. He was looking at the census data for agriculture operations within the state of Utah by a county basis, and I can send you this data. But he reached out to me because as he was looking through this, he's doing, I don't know exactly what his written work is, but he was looking at census data from 2012 all the way to current. And he said that San Juan County was actually growing in agriculture operations versus the rest of the counties across the state. We were the leading growing county in agriculture operations by about over 500 operations since 2012 increased in agriculture. And he was asking why. And I moved here 6 years ago, but what I've understood from the community is that as generations have passed, land has been passed on, families are honoring that agriculture heritage. And though farms are not as big, they're being divided, and people are taking up agriculture practices as their families multiply and grow and divide. So that's one. 2, we don't have the development that has taken place. We don't have the access to water, but we can still have agriculture operations exist even with little or minimal water. And San Juan County is a case of where we've been able to sustain and try and thrive ourselves with that basis. The other thing that I've looked at is agriculture land that may have been bought and sold. Right. We have people from the outside like California, Colorado. I've met quite a bit of number of them. They want to get away from urban environment. They want to come back to a community where they can have a little bit of freedom and they're not going to be door to door, kitty corner, stacked on top of each other. And they have a little bit of ability to live an open life and be able to connect back into the environment. They also want to honor and respect the agriculture heritage of what San Juan County has developed and grown upon, and how people have lived off the land. So we have lots of people, new, old, coming in, people that want to homestead, people that want to stay and honor their family heritage. As operations divide, we are actually growing in agriculture. And so as Talia and I connected, we started to look at, well, how can we capitalize and support our agriculture industry that is actively growing to get markets here that support them to grow and develop? How do we help them sustain? Fertilizers out of the question. Conventional practices, like they're old time and spent. Our producers are just struggling to find an avenue of how do we securely, safely, with confidence move forward with our financial circumstances to stay in operation, to continue keeping the land in agriculture, to continue honoring, the environment and what we share within our communities. And then also the impact of how do we start to become locally sustainable within ourselves as a community. I think we saw during COVID, we're not sustainable. We had people coming to us and getting our food, and we didn't have a resource. We were some of the last stores to get resupplied because they were trying to ship all of the product up to where the main populations were. So how do we remain sustainable? How do we support each other? And the only way that we can do that is by looking at the basics of what everybody needs, which is food, water, and shelter. Everybody needs food. So can we capitalize on growing and supporting our local agriculture production systems so that way we can ensure that, one, we have food, two, we can create an industry. We could actually start looking at how can we start revenuing and supporting our own local economy here with agriculture. Among the many other ways that we already have our economy supported. So with that, I can, did you want me to cover anything else?
No, I'm going to add to that and then I'll give it to John.
Okay. Give it off to Talia.
So the other thing I want to add is we do a lot of reports in our county, but we don't always go back and use those reports. So that's some of the things that have been happening. MAC initiated with CERTA to, you're going to have to help me remember what it's called right now. It's the wood one. Biomass. Thank you. Biomass report. Gosh, I'm struggling this morning, you guys. So the biomass report, we didn't score very well, but we have the potential to be able to use the algae and use the biomass to create and activate the char. And I think that's a super unique thing because that's also something that can become a product out of our area and serve the Four Corners region. And also, again, going back to the fertilizer, it allows us an opportunity where other counties may not be able to catch up as fast, but we're trying to be on the being innovative in how we're approaching, how we're working with our economic development. One thing that I wanted John to mention too is kind of how these pods are set up, because we are going to try and see if we can get them investor and grant funded as much as possible. And there's a couple of reasons why we want to take that approach. Do you want to talk about that part?
Yeah, I'm definitely open.
Yeah.
I just have a few points I'd like to make. So, Talia's described the financial situation of the county to me, and it's apparent that we need to go and get grants. So one of the things that I've discussed with my team, is making a list of grants so that we could pursue these together. I have grant writers on my team. Talia has grant writers. This is definitely going to be a teamwork effort to getting the pods paid for. So one of the things that we discussed doing is setting up 3 sites. AirBuild is an investor-funded tech company, like Silicon Valley type of company, and we will put up $9 million for the pyrolysis and algal harvesting equipment because our money comes from selling carbon offsets to Microsoft. So us operating that equipment, we'll put up the money for that to do that. In terms of getting the pods themselves paid for, we'll have to pursue grants together. It's going to be Richard on my team, and then your guys' teams getting together to do so. So, few things that I wanted to mention is about the water. I feel like I didn't go into depth about it. The pod system, how it works is it's not just algal water treatment. There's a few other things that we combined to make it feasible and make it smoother than, well, you guys know the other 2 options are either build a wastewater treatment plant or a sewer pond. Sewer ponds are great because they cost less. Unless they start leaking, then they could cost more. Or when you have to expand them, obviously then you have to look for land, which you guys have in abundance and it's not a problem. But then just building more and more sewer ponds to the end of time. Wastewater treatment plants are great because they treat a lot of water and they do it quickly. The problem is they're expensive operationally, and then initial capital expenditures huge. So the air build pod, what it does is it combines both into one because it's continuous water treatment using UV in the algae, and then we use AI to completely control everything. So OpEx is extremely low. It's fully solar powered. The site images I just sent you, the construction images should be in your. Oh, they should be in your email. But we did install the solar on the ones in Green River. It's still under construction. You could see this pod is definitely smaller than the ones in that image. So the whole goal of this was to get a lot of water treatment with extremely low operational expenditures. And yeah, some of these might be flipped a little weird. That's a truck, and they're installing the walls right now of the site. But I would just go to a more recent one. That's a rendering of when it's going to be finished in Green River. See, it's connected to the sewer lagoon.
Sorry.
What's the cost of that?
So that's your sewer.
So those that site is going to cost around $3 million. You see the skinniest one on the side, everybody?
Mm-hmm.
That's the one we just built, or it's almost done being built. It'll be done in about 2 weeks.
So if I can ask you, are talking about expanding like sewer lagoons, what, or would you just go with the ones that are already in existence?
You're talking to my scientific mind right now. So this is something we're actually thinking about, but it requires a lot of research to do a conversion. And we don't want to take a risk on a conversion unless we're absolutely sure that we can do it. If we were to do a conversion, the great thing is you save cost when it comes to excavation and making a base. But with the sewer lagoons, a lot of studies need to be done, the current status of them. You know, especially if they're bentonite layer, they start leaking. So we can get studies done and see what the feasibility is of that. My point is I just don't want to make a promise on something we haven't made a decision internally yet.
So I guess my question is so for example, these down here that exist, and you talk about the study, but so to create your own from scratch, then would you divert what's in those to yours, or you would have your municipalities reroute to yours?
We divert.
Making the connection there.
The sewer lagoons would just feed into ours.
Okay.
It would be the difference being normally you guys would build another sewer lagoon right there,
Right.
and then it would start feeding into that. Instead, it would feed into the air build system, which is continuous water treatment. It would be emptying the sewer lagoons.
Okay.
Yep.
So you'd have to work with municipalities to engage what is existing to, okay,
Yeah.
bridge that gap.
That's our next step, which is why we were going for letter of intent, so that people know that they were actively doing that. It also helps with finding investors and grants
Okay.
over time. And some of our start may be just finding the studies to make sure that we're picking the right spots to do that. One other thing I would add that makes this really valuable is that there's a lot of algae strains that we can use, and one of them can absorb the radioactive issues that we may have, and so which is really big for our area. Also, it helps our ranchers. So we have a lot of livestock that are not drinking the water. The water's too heavy in the metals too. And so that is another way that we can use this on a smaller scale. So those are what we're looking at. And then one of the things that we've discussed is looking at wells. So they're able to do this for wells because that's another issue in our area that we have. We're also going to be presenting to White Mesa because they are looking at it as a secondary option. So they'll go through their own system and then again, possibly through this system in order to feel more confident about the water. And that's something that is for economic development that I think is very important as we're having these conversations about energy, is that we're addressing our mining and the issues that are specific to our area. Do you want to add to that? Sorry.
Yeah. So one thing I didn't even touch on was the waste processing portion of it. As I was mentioning before, we have to purchase pyrolysis machines to process the algae. And pyrolysis is one of those machinery types where there's not a lot of U.S. manufacturers. And the ones that do manufacture them, they either make really small ones and they make really big ones. Our algae needs something sized in the middle. So what we did in Green River is just buy a really big one. the thing is because we have all of this extra pyrolysis capacity, Green River, we just did the deal with them to reroute their waste dump to it. So we took control of all of Green River's organic waste, and we're producing even more biochar from that waste, mixing it with the algae for their farmers. So it helped us bump those biochar numbers up, or well, we're installing it in 2 weeks. So bumping those biochar numbers up. At the same time, we earn money from carbon offsets. So this is just me telling you our business model. We sequester more carbon, we make more biochar. It'd be interesting to see if we can do something similar in San Juan County where we find organic waste, such as Russian olive trees or other parasitic type of waste that would get removed either way. And then we just mix it with the algae and we make super nutrient rich biochar. Algal biochar is the first time it's ever been done. So AirBuild is the first company to do it. And the benefit of it is it's extremely nutrient dense. And I'm sure Reagan can speak to that. But I didn't say the nutrient or the waste component of it right away because I wanted to lay out all the information in a process. It's what we do is definitely a lot in terms of how circular it is. But yeah, it's definitely something to know.
One thing I was, down the reservation, we had lots of abandoned wells. People are afraid to use it because the arsenic and uranium. So if you have small units, because usually the houses are not next to each other, but they have a communal where a few families live, maybe make it smaller using the well water, plus their waste, whatever waste it,
So-
you know.
Yeah, we've definitely talked about that, but there's a lot of operational and logistical challenges for that. The reason being is the AirBuild system is two components. It's the pods that treat the water. Those can be miniaturized. But the other component is the algae processing equipment. And no matter what, it costs us millions of dollars each time we buy it because we'll earn carbon credits. So the site needs to have a minimum size for how much pods we install. Then it allows us to offset the cost of all of this algae harvesting and processing equipment. So with the wells, the concern that I have is that too many spread out far away. If we can somehow centralize water source, then it makes everything much easier because we can have a site dedicated to it and then have one set of processing equipment or machinery. Or we do a study on which wells have enough water source where we can install a system. There's so many ways around it, but I wanted to give the concern because I don't want to be the guy saying we can do everything. There's science and there's challenges and logistics and operations and cost and yeah.
I'll talk to you and tell you.
Yeah.
Because Halchira is a community. They were, I'm a member of another commissioner, 7 county commissioners, and we're looking at water solution for Halchira. It's a community, and maybe that would be a place that something like this
Yeah,
on a
it's
bigger scale can work.
it's on the list to look at and go and see if that's something of interest and do the studies for. So part of the grants will pay for the research and development in the areas that he currently isn't able to go into. And then the hope is that we can be the pilot program for some of them. So then we would have the infrastructure. The other thing is that we would own the infrastructure. They are really just looking for the
Pyrolysis equipment.
And so, which is an added benefit for us because once we get it, like we don't have to worry about them leaving. The other addition is we can train the technicians locally to take care of those. And so because it's so unique and different, as we do our project areas or we find a pilot program, like I think that we're going to find some really interesting solutions for our area for all of the different things. But I really like the model. I think that it's going to be a very good benefit for us.
And also, we had the Utah money this down the reservation.
Yep.
Under the water rights. There will be some funds maybe for infrastructure there.
Yeah, that's a good point. For Green River, we went and got our own water right because it was our first time and we just wanted to prove the system from beginning to end. If support can be given on water rights, on permitting, on permissions, anything like that, that would be incredible. The other thing I wanted to mention is earlier I was talking about how the system is regulated by machine learning. to lower the operational cost, we would have to train and hire technicians to the sites. And that's something that I've been discussing with Reagan, the curriculum that would be required. We just actually made our first hire in Green River. So that felt awesome. But me, that technician in Green River, and Reagan will work together on doing the same version in San Juan County. I believe the number of hires we would need